What are the elements of a copyright infringement claim?
Hey, thank you for the lovely bouquet. You're sweeter than a peach. Lately I've been feeling so cool. Top to the bottom, just cool.
This is probably where people get the misconception that you can copy X amount of seconds of a song,
what I like to call the 4-note threshold,
without it being infringement. That is not true. I'm an entertainment attorney. On this channel, I talk about the legal issues that artists, athletes, and creators face in the entertainment world. If you want to hear more, follow along. Copyright infringement actions make the news all the time. But what does someone have to prove to win a case? In the United States, there are two things you gotta prove. Number one, ownership of a valid copyright. This may seem self-explanatory, but you gotta prove that you actually own the copyright you have before you can be successful in your lawsuit. Challenges to ownership may be something like someone else created it first, the work doesn't have enough originality to it, or it falls outside the scope of copyright protection. A recipe, for example, falls outside the scope of copyright protection.
No. It was his job to be unexpected. It is our job to follow the recipe.
The second part of a lawsuit is copying, and this part's where it gets a little bit complicated. In the United States, our courts have built up a lot of case law for copyright infringement actions, but here's the 10,000-foot view. Courts break up copying into two parts: A, actual copying, and B, legally significant copying. Let's start with A. In order to have infringed on someone's work, you have to have actually copied their work. Technically speaking, if you were to accidentally write the exact same song as someone else and you never heard their song, there wouldn't be any actual copying, and so there wouldn't be any infringement. But don't get too carried away here. There's a very famous case where a court in New York actually found that George Harrison had subconsciously copied, even though there was no evidence of actual intentional copying. With a famous enough song, it's possible to prove subconscious copying. Part B is legally significant copying. This means that what someone's copied has to be enough to be legally significant under the Copyright Act. This is probably where people get the misconception that you can copy X amount of seconds of a song,
what I like to call the 4-note threshold,
without it being infringement. That is not true. There's no bright line rule here. Courts are gonna look at every single case differently. So just because copying 2 bars of music here was okay, doesn't mean it's gonna be okay in this case. So don't fall into the trap that copying a certain number of notes or bars of music is not copyright infringement. Every case is different and there's no bright line rule. There's tons of little exceptions. There's fair use, there's other things I haven't talked about, but those are the big elements of a copyright infringement action. So if you can prove ownership of a valid copyright and actual copying of a legally significant amount, you got yourself a copyright infringement action. Let me know in the comments what you want to hear more about, and like, subscribe, follow along for more.